everybody. Good evening. My name is Jean. I teach ESOL, and it includes the Work Ready English course with the Launchpad Collective. I am not an employment specialist, but having the course that I teach here at TLC involves getting people ready for work at all sorts of levels, and including understanding their rights, responsibility, and contracts. So I got interested in the matter, and I've put together this little talk. I hope it's clear enough, and if there's some questions, we can go through that. I might ask you that there's too many of us to ask to introduce all of you. I hope you can see my screen. Yes. And I will probably use the chat just for its quick little yes or no, if you know how to access your chat and be ready for that. So, employment contracts. So I was going to ask generally in the chat, if can you put very quickly if you have ever had an employment contract, just put a Y for yes and an N for no. All of you just throw yourself in there and put a comment, put a little yes or no. I'm just curious if most of you have had. Okay, so there's a few yes, half and half. Okay, okay. Some of you are looking for a job, yeah, so it's good to know. Okay, good. So a little quiz. So you put T for true or F for false in the chat again, just to see what we get. So true or false? An employer does not have to give you a contract. Yeah, it looks like you guys get it. Yes. Absolutely, it's false. You must work extra hours if your manager tells you. Ah, la. You don't want to work? Okay. You do not get holiday pay. You're right. Yes, it's false. It is false. You do not get holiday pay if you are part-time. Okay. Yeah. Okay. I got clever people here. Your employer can change your salary without asking. Okay, good. And 0 hours worker have no rights. If you know what 0 hour workers are, some of you may have done that sort of work. It's not very stable work. Ah, there's somebody that believes that's true. Okay. Okay. So regarding, I'll come back to the 0 hour contracts because you don't know about AH, you don't know about 0 hour contracts. It's a very unstable way of working. They can call you to work, they can tell you tomorrow you have no work. So you don't, so it's not a very stable situation, but you do have rights. Um, Okay, so a work contract is an agreement between the employer and the employee. It can be written, verbal, or implied. Now, the best form is always written, and the verbal means that you can discuss the terms of work, of your employment, discuss your salary, discuss your hours, and it is legally binding. Implied means that the moment you work for someone, you are considered as having workers' rights. It's very important. The moment somebody says, come and work for me, you say yes, you turn up at work, they pay you. Um, yeah, there you go. Somebody's got a 0 hour contract, so they know how insecure that can be. They pay you, and then it's implied that you've got a right, and there's sort of a virtual contract because you are protected also by law. Obviously, the best would be to have a written contract. It's always the best form because if you have any issues, it makes it easier for you to demonstrate what was in your contract in order to make your point and fight your case if you have issues, and it's clear so you understand what's happening. So I've written here a job offer is not a contract. A lot of people may get a letter of employment telling you congratulations or I'm happy to welcome you to our company and we are offering you this job. That's a letter of offer, which is not a contract. So not confuse those things. So these are example of things that you will find on a contract. If obviously you will have the name of the employee and the name of the company. Generally, you've got the the title of your job. In this, I made this job for my friend Ahmed Ali here. Your start date, where you work, place of work can be important. So, and a lot of these things are negotiable. That's why you need to be clear about them. They have to be in your contract. For example, if you worked for a national company, you could ask to travel to go and work in another branch. That could be part of your contract. And you could also travel for training, go to the head office for training or go to the head office for meetings. So these things have got to be in your contract because if you don't have a car and you don't have the means to travel, they can't force you to travel if it's not in your contract. So these things are important to have. Obviously, your salary, whoops, sorry, which is, and normally in a contract, it is stated when it will be reviewed every 6 months, every year, and usually performance based. So it's an opportunity for the employer to discuss with you your performance and to review your salary. And it's always often stated in a contract that there will be salary review. Most of us want to know that it will happen because it's not very comfortable to go and see your employer and after 2 years nobody offered you a raise or anything. So these things are good to have in your contract. And then obviously your working hours, what they are, and you have more that you can have in a contract. You have break times that you can have. So normally 30 minutes per shift. Again, that varies. It depends on the amount of hours that you work. There's a minimum of 20 minutes in a normal day's work or 30 minutes, twice 15 minutes. Your holiday entitlement, usually in the UK, you get 28 days minimum. And sick leave. So sick leave is important because it's defined very differently per company. So I'll come back on that a bit later, explain about statutory sick pay. That's it's a concern for a lot of people. The notice period. So notice period again can vary, but it will be stated in your contract. Depending on what sort of work, it will go anywhere from a week to a month to 3 months on some major jobs. And then reviews, obviously, always similar to the review for your salary, for your pay. It will tell you you have a monthly review, one-on-one meeting with your line manager. And then obviously you sign and date, and the company signs and date. So these are the minimum things that you will find in a contract. Okay, so I don't think this is the most clear graph that I could come up with, but so these are all situation of what happens if you are sick at work. And these things are defined in your contract. The basic one normally is you're sick 3 days, you're unpaid. So the case number one situation, the statutory sick pay only. So first 3 days, you're not paid, and then they pay you after 3 days, and you get the lowest level of pay, generally £109 a week. And if your employer doesn't pay it, the government should pay this. The second scenario, your employer will pay your days, your first 3 days, and then your employer may drop to the statutory sick pay. That's which is usually fairly low. And then the third case scenario, I mean, that's a very nice employee. He pays everything the first 3 days and he paid everything after 3 days and you get your full pay. And that's not as rare as you think. A lot of employers are happy to cover you for a period, but it's got to be stated also in your contract. You have to be clear about that because if you take two in the first case scenario, if you only take one day, 2 days sick, you may not be paid for them, and that may be troublesome for you. Okay, so and there are additional things that you can find in a contract, depending on the sort of work that you do. They may require you to have a DBS check, which is a criminal check if you're going to work with children or with vulnerable people. Uh, you need to have health and safety regulations. Um, you need to understand that you will need to have training, which will be specified in your contract. Um, Again, same thing. Food hygiene, if you work in a restaurant, that might be specified in your contract that you need to have training for these things. And then obviously, if you're a doctor, or a lawyer, you need to keep up with medical advances. You need to keep up with the law. So all these things, again, but these are more complex contracts. They may tell you about the uniform dress code, and they may point out to you that you need to keep confidentiality about your work. So you're not allowed to talk about what you do at work to other people. Or more specifically, if you work in a restaurant and they have a secret recipe for a certain meal, you cannot go and open your own restaurant and use that same recipe. It's these sort of things that you might find. So these are extra, they're quite specific. So the point is that not all contracts look the same, and some are very detailed. And they don't look really, they're not written as bullet points. Whoops, sorry, where was I? Like these. It's usually written in the form of a letter. These are just bullet points to make it simpler. Okay, where are we now? So we've done this, yes. Okay. So I've just a few questions again, simple questions. So you can just put a Y or an N or a T or an F, true, false. Are these following things in the contract, the dress code, according to you? Give me an answer in the chats. What do you think? The dress code. Are you supposed to dress? Maybe. Maybe that's a good one. Yeah, I like maybe. Okay. Sometimes. So maybe. So it can be true, it can be false. Usually, these sort of details you're going to find in the handbook. There's often, yes, in some contracts, absolutely. If you work in a restaurant, the chain that's got a specific uniform, they will tell you that you have to wear the uniform. Or I remember working for a company where I had absolutely to wear a tie, which I never do. So I had to buy myself a tie and a suit and go to work with a tie and a suit. It was in my contract. I was not allowed to go in that office without a tie and a suit. Um, so there's the handbook, which is different from the contract. So you have a contract, which are the important legal details, and then the handbook can give you all sorts of extra. It's very common about the uniform, about company policies, what they do in the kitchen, and all these sort of extras. When the Christmas party is going to take place, that sort of thing. Okay, should your salary be in the contract? True or false? Yeah, I think we all agree. Yes, it's always included. That's the basic that you really want. Holiday days also, we've talked about that already. So it's also a legal requirement to have this in your contract. Should you have your manager's name in your contract? Hmm, okay. Okay. Yes. No, line manager instead. Yes, 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 yes. That's a good answer. Yes.
Pwede
No,
ba
you
po
don't.
ito sa Takoy? Pwede
Sorry?
sa po ito sa Takoy.
I didn't hear that. Sorry. You okay? Yes. Okay. Um, it's not essential. The manager can change. What's important is it's specified that your line manager, wherever, whoever he is, so it will be specified like the store manager or the floor manager or the warehouse manager. That's the sort of name that you will have, but you won't have a name. HR is very important. You're absolutely right. Yes. Whoops. Notice period. Do you think you'll have the notice period inside your contract? Yes, yes, yes. I think, yeah. True. Yes, true. Yes, yes. Good. Yeah, I think we all agree. You need the notice period. It's very important. Will they tell you about break times? The amount of breaks that you can have. I'll explain the notice period. Yes. Okay, the notice period is the time you have to give your employee when you want to leave your job, when you want to resign. Uh, Most commonly in office jobs, it's a month. So you've been working a few years for a company. You go see your manager and you say, "This here is my resignation letter." Of that's another subject, but it's important to write to break your contract. Actually, you need to write a resignation letter, and I said from today, I give you 1 month's notice, and in a month I'm gone. So he's got a month to get organized, find somebody else to replace you. You might need to train somebody else for a month to do your jobs. That's why the notice period is important. In more physical work, let's say working in a warehouse or working at McDonald's, I guess 1 week is usually enough. They can probably replace you quick enough. So it depends, but that will be specified. That's what a notice period is. I hope that makes sense. Okay. Break times. Break times. We said yes, yes, yes. We said yes, everybody, for break times. Usually included, yes. And if you make bonuses, do you think they'll be included in your contract? If does everybody understand the idea of bonus? Okay. I think it depends on the sort of work, obviously. But if it's specific to the job, it's usually put in the contract. If you do a sales job, for example, you will want to know that you will make 2%, yeah, bonus or commission. It's the same thing. Commission, yes. You will make 2%, 2.5% profit bonus or commission on your sales. And that needs to be specified, which can be renegotiated when you have your review with your manager. Well done. Okay. So we've covered pretty much the things that you will find in your contract that you need to be aware of, that should be written down before you sign it. You get a copy, your boss keeps a copy. More specifically, I wanted to touch upon rights at work, and some of these rights are covered in your contract. So because you should always receive at least a minimum wage. That's the law in the UK. And you should get a pay slip. Everybody should get a pay slip and protection from illegal deductions. So what could happen here is that your employer may be disappointed about something. He believes you have done something wrong, and he tells you, I've taken 50 quid off your pay. That's a no-no. That's illegal. You can't do that. Uh, you got to raise a serious case with the employee to be able to do that, and you're entering the legal realm if you do that. You're entering the legal arena, so you are protected. Your salary is your salary. So I have a question again. If you want to type yes or no in the chat, if your employee pays you cash without a payslip, is this okay? I'm gonna have to ask Oksana if she's ever been paid cash with no payslip. Illegal is a good one, maybe, maybe. Yes, no, because there's no evidence. That's a good one. Yeah. So where are we? If your employer pays you cash without a payslip, is that okay? Usually not okay. So a payslip is a legal right. You can be paid cash. Yes. Cash is not illegal, but it needs to be declared, in which case you need a payslip. Somebody can pay you cash if there's a payslip that says this is what you've been paid. And now the difficulty obviously is that how is the national insurance paid? I guess the boss pays it himself, but these are situations that you don't want to find yourself in. I've put little red flags here because you could be looking at someone trying to do some tax evasion or trying to exploit you, and you never know if you're going to get paid. Uh, oh, it's not very secure way of going about things. So I'd watch out for that. Um, Working hours, maximum in the UK is 48 hours a week. Again, if your contract says that you can work 55 hours a week, you can if you want, but they can't force you to. If it doesn't specify, it cannot force you to work more than 48 hours a week, which is a long time. And then you have rights to breaks, 20 minutes if your shift is longer than 6 hours. And you have to have at least 11 hours rest between shifts, between each day, minimum. Whoops, sorry. Um, and 1 day off a week, minimum. You can agree to more hours, but you cannot be forced. It's always negotiable, even beyond the contract. So you have a contract, but if verbally you negotiate with your boss, okay, I'll do an extra few hours because you need me. That's not impossible, but you cannot be forced. Again, you need to get minimum, if you work 5.6 weeks, sorry, if you work, yes, the full time, you get 28 days holiday. And if you're a part-time worker, you also qualify pro rata. I'll explain what pro rata is, and the statutory sick pay available if eligible. So negotiable on your contract. I hope that's clear enough. Okay, so I have a question again. If you work 3 days per week, do you get holiday? What do you think? Yeah, so that's what pro rata is. So if you work full time, that's 5 days a week, you get 28 days. But if you work 3 days a week, you get a ratio of those 28 days. So the calculation is simple: 28 days divided by five. So yeah, by 5 days. That will give you what you would get for 1 day of work a week. and then you multiply that by 3. So you would get 16.8, it's funny time, 17 days holiday if you work 3 days a week as a part-time worker. So part-time workers have the same rights, they're just adjusted. Protection from discriminations. Some of these things could be in your contract, but most of the time they're taken for granted because there are legal requirements in the UK. That is why on a CV you do not put religion or gender or age. They may ask about disability, which is a different issue, but these are protected characteristics. So you should never be under pressure at work for any of these things. Responsibilities. Okay. So now the employees, yeah, when you have a contract, you have to do what your contract tells you. So you have to do the agreed job, you have to follow the rules, you have to be on time, and you have to respect confidentiality, and you have to give notice. Again, that famous notice period. It's very important for employers, the notice period. And I have a question again. Can you just stop coming to work without telling anyone? Okay. I think we all agree. We're all reasonable people. So, no, this may be a breach of your contract, and it would what we call in employment jargon, legal jargon, absence without leave, without notice, sorry, absence without notice. And it could affect reference or your final pay. So even though you're not allowed to be told that you did not do a good job and we will cut your salary, you cannot be told that sort of reason to have money cut. But if you don't turn up at work, then you might get yourself into some legal issues with your contract. So the better option, if you're not going to turn up to work, is obvious. Call your boss, speak to someone, give some proper notice, and explain the situation. I believe that is fairly obvious. Okay, so there's a little video I wanted to show you. What I will do also, you must also notify your employer when you feel sick and cannot come to work in a reasonable time. Absolutely, yes. Sometimes it's difficult in a reasonable time because you wake up in the morning and it's like maybe it's 6:30, the time you get up to go to work, and you realize you're sick and you try to call your boss and the shop is about to open or the office, and so it's last minute, but okay, cool. Sorry. So I wanted to show you this video. Let me just change the sharing screen. And I hope that you can hear the sound. So where is it? Where is it? Where is it? Where is it? Ah, there you go. Share. No, not working. Ah, yes, I think I know why. Excuse me. I've got to close this. Whoops. And share. So I hope everybody can. Okay. If no one can see this, yes, we should be done soon. I don't know how long I've been going. It's the first time I do this. I think an hour. Oh, you're saying an hour could be reasonable where possible. Absolutely. I thought you were talking about the this presentation. Okay. Okay. Can you hear the sound?
Yes.
Yes.
Okay, good. So I'll start again. And I'll give you the link to this video in a moment if you want to watch it again on YouTube, but it's being recorded.
Let's talk about work. Is your work safe? Do you earn what you were promised? Do you have a contract that explains your rights? If not, there's something you can do. At the Work Rights Centre, we believe that everyone has the right to work that is fair, safe, and that pays. Getting your employment rights starts with finding out your employment status. An employee who works regularly enjoys the highest level of protection. A casual or 0 hours worker has many rights too. As for the self-employed, their rights are limited, but they are still entitled to the pay they were promised. Remember, even if you don't have written terms and it all seems informal, if you work regularly, long-term, for someone who controls what you do, you are at least entitled to the protection of a worker. If you work on an occasional basis, you are at least entitled to pay and safety. So let's get to it. Step 1. Once you know your employment status, it's time to talk to your boss. Try to negotiate your terms, suggest ways to settle, and remind them that you are legally entitled to a number of protections. Step 2. Start to gather evidence. Any text messages or phone logs, emails, pictures, timesheets, or witnesses that may support your case. Step 3. Write a letter to your boss. Use the evidence to write a grievance letter, or, if you've stopped working, a letter before action. Outline the issue. Suggest a solution. Do you need...
Does everybody know what a grievance letter is?
No.
It's a
No.
letter that it's a letter that explains the issue that you have. That's what a grievance is. A grievance is a problem. Were there certain things, before I keep going, that you would like to know that you didn't quite understand? Was it a bit too quick? Because I know maybe not everyone's English is perfect. I understand this. Was there anything that I could play that you need to know? No? Okay, I'll keep going.
back pay, a contract, annual leave. Then, give your boss a time to address it. Always send the letter by recorded delivery. Step 4. If nothing happens, it's time to go to court. If you think you're self-employed, you can take your boss to the small claims court. If you're a worker or an employee, first contact the Advisory, Conciliation and Arbitration Service. ACAS will try to mediate the issue. If that fails, you can finally take your employer to the Employment Tribunal. It sounds complicated, but we can help at the Work Rights Centre. Take a moment to learn more on our website or visit us for a free and confidential consultation. And remember, everyone has the right to work that is fair, safe, and that pays. Work Rights Centre, www.workrightscentre.org.
There you go. So let's go back to where we were. Oh, I need to find, what am I looking for? Oh, yes. Is that it? No. Share. Okay. Can you all see this again? The presentation? Yes?
No, we just see the same video.
Yeah, the same blank video. Is that good?
Yeah,
Yes.
now
Okay.
good.
Thank you. Okay, so let me jump to so we've been through all this, and you know all the answers to this, which is very good. I don't know where's the screen for me to go directly. Ah, there we are. Okay, slides. Thank you. This is a bit new for me, I will be honest. So we saw the video, yes. Okay, so in the end, sorry, we got to the end. It was a bit short, or maybe I talked too quickly. And there would have been more interaction, but there's so many of us that I don't think it's easy. Practical resources. So this is the website address of this video that you were looking at, and you can get consultation with them. ACAS, which is, if I remember, what does it stand for? Yeah, the Advisory Conciliation and Arbitration Service. So it's an independent body that helps improve relationship in the workplace, and it provides advice. It's impartial, it's neutral, and it's there to prevent disputes or to help stop dispute from escalating to go bad. So they're good to talk to. And you always have the Citizens Advice Bureau, always. The website gov.uk, always. And trade union. Some companies have unions, so you will have a HR or unions, good people to talk to again. And just make sure always to keep a copy of your contract, of your pay slips, and any email communication. There you go. Any questions?